U.S. Immigration Attorney Sharifa Tharpe. I'm live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I may answer your questions. I'm here on YouTube. I'm here on Instagram. I'm here to go ahead and talk to you about a particular topic that may be of interest to you. I'm also here to take your questions. So go ahead. You can put your questions in the comments from now. No need to wait until I'm finished with my topic. And then as soon as I am finished with my topic, I will get to your questions. Now, I have a question here that I always get, and it's how long do I need to be married to the citizen or resident spouse to apply for VAWA, right? How long? And the answer is there's no length of time that you have to be married to the spouse to apply for VAWA. This is because abuse, mistreatment, extreme cruelty, these can happen at any point in a marriage. This can happen the day after you're married. And so if the day after you're married, you end up experiencing extreme cruelty, and maybe that was the first and only instance of extreme cruelty, then this can qualify you for VAWA. So if you're married to the spouse for 10 hours, and it's on the 10th hour that you experience mistreatment and you decide that you don't want to go through the immigration process with this spouse, or you want to apply on your own through VAWA, you're able to do this. The reason that there is no a timeline on how long you can be married to the spouse is because extreme cruelty, abuse, mistreatment can happen at any point. And can you imagine having a policy in place that says that you should stay married to an abusive spouse or a spouse who mistreats you for 2 years before you can apply for VAWA? Probably many people would not survive that time, and it would lead to a lot of tragedy, because a lot of people would feel like they need to stick out this kind of abuse. They're getting traumatized, they're experiencing abuse that's life threatening. In some cases it can drive them to depression, to hurt themselves. And so this is why behind VAWA, the policy behind VAWA does not have any time limit on marriage, like how long you should be married before you can apply for VAWA. Now, there are other requirements, right, that are included in this application for when you're doing it based on a spouse or a relative, and that's you have to show that at some point you lived with the spouse. Now, if you say you lived with the spouse when before you were married, that does count. In this case, they did update the policy manual to say if at some point you were living with the spouse, not necessarily during the marriage, but at some point, you can still qualify. So you don't necessarily even have to be living with the spouse while you were married. So that's another very important update to the policy manual that the USCIS has implemented, that allows a lot more people to qualify for VAWA base. Because another thing is, it's complex, right? When you're in a situation where you may love someone, or you may have a relationship with someone, a genuine relationship with someone, but maybe you did get married, but you saw the red flags and you decided you didn't want to live together, or you experienced mistreatment before you got to live together, so you never lived together. So circumstances can be different, and because of situations like that, they have now opened up they have updated the policy manual to allow people who have not necessarily lived with the spouse during the marriage, but lived with them at some point, to qualify for this. Now, there are some important time limits that you have to keep in mind. There is no time limit, by the way, on say you separated and now you're just learning about this VAWA, that you could potentially qualify for it, but you were married 20 years ago. You experienced this mistreatment or abuse 20 years ago. You're now separated from the spouse. Can you still qualify? Absolutely. There's no time limit on when you can apply for VAWA when you're still married. If you're separated, you're no longer experiencing the mistreatment, you could still qualify for this. But there are deadlines when you do get married. Now, if you do get, divorced, if you do get divorced, then that's another matter. If you get divorced, you have 2 years to apply for this. So the clock is ticking. 2 years from the divorce, you have to then move on and apply for VAWA or lose your eligibility. And that's non-negotiable. There's no, showing reasons why you missed the deadline. Need to make sure you're on it. Another, if they have passed away or they were deported, you have 2 years. So yes, if they have lost their citizenship, if they've lost their permanent residence, but they mistreated you while they were a permanent resident or a U.S. citizen, and now they've lost that status, you have 2 years from the date that they've lost their status or they got deported to go ahead and apply for VAWA status. So even though they may not have it anymore, you could still move forward with this. But keep in mind that when you've ended the relationship, not through separation, you can be separated and still legally married, you can still apply at any time. But you keep in mind that the longer that the time passes, is the harder it is to get the evidence you need to put together. Evidence is flexible, but it doesn't mean, the more solid the evidence, the better. So document everything. If you're in that situation or you just came out of it, make sure you keep all your documents, keep evidence of their status. Make sure you document all the messages between each other, any photos you have, any pictures of any destruction of property or anything like that. Make sure you keep it. Any recordings, make sure you keep that in a safe place, because that evidence is going to be important, as well as your memory. So make sure you log dates down, write dates down that you remember of instances of mistreatment or abuse, or even good times in your relationship that talk about the bona fides of the marriage. Go ahead and make sure you document everything. But even if you haven't documented everything, it doesn't mean you don't qualify. That you can still apply. This application, it is possible to get it approved based on your statement. However, keep in mind this when you're presenting this statement, like everything else, it has to be done properly, or you will likely face a denial instead. Because your statement, coming from your memories, coming from truthful events that happened to you in the past, it's going to be accepted as evidence only if it is consistent, if it's credible. If the officer finds anything that makes your statement questionable, it means that they can deny it on that basis, and then you wouldn't have any evidence. So evidence is flexible, but it doesn't mean that you can afford to be sloppy with the evidence or just draft up any old thing that can actually be damaging. So this is where representation matters when it comes on to this type of application. All right, so this is the information I have for you today. And, as the week goes by on my lives, I'll come with more information. But now it's time for you to ask your questions, and I will go ahead and answer those questions as they come in. So I do see on here, on YouTube. So, how long after approval of VAWA before I get my green card? Both cases filed together. So, I can never guarantee processing times. And once you get approved for VAWA, if you said you filed everything together, it means then that they will automatically then move your case over to the adjustment of status case, and that can take anywhere from 6 months to another year to go ahead and approve you or to get scheduled for that green card interview. Let's see. Can DACA recipients apply for the green card? It's possible, but DACA is deferred action, meaning that it doesn't give you, it's very important. It's a very important form of relief, but it's not, unfortunately, it's not a status in itself. It's a form of protection against deportation or any kind of immigration enforcement. So this is why, you know, we do hope for a permanent solution for DACA recipients. What this also means is that you still have to independently qualify for permanent residence. DACA alone is not going to qualify you for permanent residence. All right, so I'm going to scroll through and get to your questions. So hang tight. Go ahead, put those questions in the comments as I'm here. Hi there, Neviwu. It's nice to see you. Go ahead, put your questions in the comments so I can address your questions. I'm gonna go ahead and repost the live. Absolutely, you can come back and look for it and it will be there. Can I submit documents even if USCIS didn't ask for them? For example, joint account, insurance, or lease agreement. Yeah, so the evidence of a bona fide marriage, those sound like it's more of an evidence of bona fide marriage. They don't list everything. And so if yes, evidence that they don't list can be included. All right, keep putting those questions in the comments. So can a sibling file for another sibling? Yes, they have to be a U.S. citizen. So my son is a 1-year-old. His dad is a citizen, but he's on probation. But the judge gave him a paper to show that his son can visit him. But he wants me to take him to the embassy. So there are a lot of questions I have here. Is that if the dad is a U.S. citizen, the son is a year old, then the son may have automatically derived citizenship from their dad. So they may not have to go to the embassy to get a visa. Are you talking about going there to register them as a U.S. citizen at the embassy? Because in that case, just by the father being a U.S. citizen, the embassy wouldn't necessarily have questions about the criminal conduct of the dad. Um, um, to be able to grant them the citizenship. I mean, there's more involved in that, but the way you're gonna go is gonna depend on whether the son is a citizen, derived from the father, or if not, then the visa would be the other option. Excuse me, I'm having a little cold, so bear with me and the coughing. All right, keep putting those questions in the comments. I'm here to answer those questions. So put your questions in the comments. Okay, so the son was born in Jamaica. So even though the son was born in Jamaica, they still could derive citizenship from the US citizen father. It doesn't matter. What matters here is the father a citizen? If the father is a citizen, and then recognizes your son as his son, which obviously he does, there is a paper here saying the son can visit him. This can be used to give the son their proof of citizenship, apply for their passport. So you may not be looking at getting a visa. You may be looking at getting your son their U.S. citizenship. So, Sharake, go ahead, schedule a consultation, so we can talk more about. I need to ask more questions to figure out what the best actions here. But the best actions may be that your son may already be a a citizen. And with the help of his father, he could just go to the embassy to go and get his passport. Oh, thank you so much for acknowledging that, Keisha. I appreciate that. So I hate to miss lives, so I had to be here today. Go ahead. I'm looking out for more questions. Go ahead, put your questions in the comments. These are all great questions. Now, while I wait for more questions to come in, um, I want to tell you how to get in touch with me. Go to the link in the profile. The link in the profile is going to take you to the website where you can schedule your own consultation. You can go to the website. The website has all the contact information. So you'll see the phone number, you'll see a contact form, you'll see online chat. All three of those lead to the scheduling coordinators who will be more than happy to assist you to get the appointment so we can talk. Especially, seeing this here about your son that was born in Jamaica, but at the time he was born, he had a U.S. citizen father. That there is an interesting matter that I would like to determine whether we can go ahead and qualify your son for straight up citizenship. I have done this for my clients previously, and I can assist you with it, but I first need to make sure that everything lines up to qualify your son. So when is immigration amnesty? So that nothing, no updates about any kind of amnesty. That has not happened, and with the political climate right now, it's looking really gloomy. I don't really anticipate anything happening before the next election, unfortunately. And if we get the wrong person in, so for example, we get Trump, or now they're talking about DeSantis. If we get somebody like that in place, then we could be in big trouble in regards to any kind of immigration reform and any progress that has been made during this administration. This administration is a great time to apply now, because this administration, they are doing all they can to speed up processing times. I mean, it can still get better, but it takes time and they're working on it. They have, changed policy to be more friendly to immigrants. And so they're trying to make changes, even though Congress has not made change because of the division right now. The president the president is still working on getting policies in place that helps people right now to get through. So now is a good time to apply. If you do qualify, and this is why it's important to schedule an appointment with me to determine whether you qualify and to get started right away. Because now, if you would like legal advice, this is where you're going to have to go ahead and schedule a consultation. We don't provide legal advice through email. We do it in a consultation to see if you qualify, and then we get started right away. Hi there, Millie. It's nice to see you. What state am I in? So I'm based in Boca Raton, Florida. However, I do represent clients all over the country and the globe. So no matter where you are, I can help you. So the cost of the consultation is $150 up to an hour. Go to the link in the profile and you will be able to see the link. You can schedule your own appointment, or you can go to the website and you're going to see everything you need there to get in touch. My number is also on all the different videos. So go ahead. What I'll do is, let me go ahead. I'm going to put in the comments the phone number. So if you feel more comfortable just calling, go ahead and call that number right now. So I'm under immigration lawyer Sharifa. That's the phone number in the chat. I'm assuming you can see the chat like me. go ahead, take that number down, call and schedule your appointment. But the way my number is all over videos and it's also in the link in the profile. So if you go to that link, you'll have everything you need to schedule your own appointment without necessarily speaking with anyone if that's makes you more comfortable, or you can go ahead and call and the scheduling coordinators will be more than happy to assist you. All right, so I see some more questions here on YouTube, so I'm going to go ahead and answer. Okay, can I file the I-824 follow to join form before I get the card? Follow to join for my kids in Jamaica. So this is a very specific. Usually, at the point that you're taking your children with you, you have to then be approved for the VAWA. So you don't necessarily, the card is usually the work permit card that you get with the VAWA once it's approved. So you don't necessarily need the card physically get the card to move forward with that. And they have all the information they need to be able to get the children here as well. So it's after you're approved for the VAWA. Can I file with the approved VAWA only? So the approved VAWA is what matters. The approved petition for VAWA is what matters here to be able to get your children here. So you don't necessarily know for the children to be able to get their permanent residence, then you would have to they have to file an adjustment of status as well, or they have to go ahead and file a petition to be able to get the permanent residence. But to come here on the VAWA status along with you, at that point, you're going to just need to be approved for the VAWA. Okay. Go ahead, keep putting your questions in the comments and I will answer. These are all great questions. So go ahead, put your questions in the comments. I'm here to answer your questions. So put those questions in the comments now. Any update on the I-130? So I wouldn't have any updates for any personal I-130s here. When it comes on to, if you want to check processing times, then you can always check the USCIS. As a client, we update our clients regularly on the status of their applications. So, any personal updates, that's going to be as the client. Any in regards to yours, if you're not a client, then go ahead and go to USCIS and check the status there to see where they are on your case. All right, so I don't see any more questions. Let me just do another scroll through. Okay, I don't see any more questions. So as usual, I'm gonna be back around lunchtime. So that's between noon and 12:30. Okay, great. So Shara, I'm looking forward to speaking with you. I think we can talk about this to determine how to move forward. Um, So go ahead, get in touch with me, get on my schedule so we can get started right away. So for those of you who want personal legal advice, get in touch with me. That's the best way you're going to get the information you need to move forward in your case and to get started. And then I will also see you tomorrow between noon and 12:30, where I'll come with my questions, come with my topic, and you come with your questions. All right? Have a great one. Bye bye.